Good morning, everyone. Good morning and welcome. A couple things. The room is a little warm, so we've asked that they turn the thermostat down, so hopefully that will happen. But welcome. Welcome to this briefing, legislative briefing on preventing and responding to child sexual abuse in Massachusetts. My name is Joan Lovely. I'm the state senator for the 2nd Essex District and assistant majority leader in the Senate, and I am in my 7th term in the Senate and have been filing bills for 6 of those 7 terms on child sexual abuse prevention. And I'm so pleased that you're all here today to learn about the work that we're doing and what we're trying to accomplish. I want to recognize some legislators in the room. I see Rep. Bowen, welcome. And I know we have more. Where are we? Right here. And please introduce yourselves.
Rep. Higgins.
Yes, Rep. Higgins, thank you. Thank you, welcome. Any other legislators in the room? Oh, thank you. Thank you for taking time out of your busy schedules to be here. I begin by thanking the many legislators and advocates who have joined us today. We have a panel up here that everyone will be speaking. Representative Leigh Davis, who has filed a companion bill with me, that she will be speaking to. We have Berkshire District Attorney Timothy Shugrue, who will be joining us remotely. Jetta, the Executive Director of the Enough Abuse Campaign. Kathryn Robb, an attorney, National Director of Children's Justice Campaign. The Child Advocate, Maria Mossaides, is here as well to support. And retired Dudley Police Chief Steve Wojnar. We've been working on these bills, Chief, for many years. I'm so grateful for your continued support. We also will be hearing from survivors and survivors' family today as well. We have Siracusa, who will be speaking. She's the mother of Christian and will be speaking. And we have Laurie Ledger, who is the aunt of Erin, and they both will be speaking as well. I want to tell you to the survivors, you're the most important, and families, you're the most important people here today. I am a survivor of child sexual abuse at the age of 6. I know the pain that you have each and every day, it doesn't go away. It stays with us. And that's why we're here today, so that we can make a difference and we can reduce, and I would say eliminate, child sexual abuse. It just runs rampant across our society. Most often, a victim knows the perpetrator. It's usually a family member, but it could be anybody in the child's life at some time during their life. So thank you for being here and the courage to share your experiences. We have filed multiple bills this session, and these bills take important steps to prevent child sexual abuse from occurring in the first place. And these bills have been gaining momentum. Just last session, the Senate did pass removing the statute of limitations on the civil side for child sexual abuse. We were very pleased to be able to get it through the Senate. We have refiled the bill, and we will continue to work on it. And we are working closely with the House to get passage this session on that bill. But we have many other bills, prevention bills, education bills, because we can't stand by and be silent. This is probably one of the most difficult issues to talk about. People really shut down. They don't want to talk about it. They don't want to think that this could be happening in their lives, maybe to their loved one, their child, but it does. 90% of child sexual abuse cases go unreported. And the average age to report that someone has been victimized as a child is when you're in your late 40s and early 50s. Almost a lifetime to come forward, the courage to come forward. And that's why we want to change the laws, make them more stronger, more responsive. So again, I'm so grateful for all of you to be here today as we take up these very important topics. Before I turn the podium over, District Attorney Paul Tucker, my DA, was not able to be here last minute. He has a funeral for a dear friend, but he did send a statement that I would like to read. Thank you for the opportunity to express my strong support of the legislation that you are being briefed on today. As a longtime police detective and former police chief, I saw firsthand the devastation caused by sexual abuse, particularly when the victims were children. As the Essex County District Attorney, I applaud the tireless work of Senator Lovely and the coalition of professionals who know that these legislative initiatives will help protect vulnerable young people. Too often, we have seen adults in positions of trust abuse that responsibility that comes with that authority. The time to act is now, as these bills will have an immediate and powerful impact in protecting children from harm. Legislation proposed, which concerns amending the statute of limitations and remedy enhancements for survivors of sexual abuse, will also correct these issues that should have been done long ago. I strongly urge passage of the Senate bills. He lists them. Upon passage, the Commonwealth will be a safer place for children and young adults. Thank you to District Attorney Paul Tucker for sending that statement and for his support. Now I would like to call up Representative Leigh Davis from the 3rd Berkshire District. Representative Davis is in her first term, and before she was even sworn in, she approached me and said, I would like to file I'd like to file the companion bill. It's the bill on positions of authority and trust. And it's the third filing, it's the third session that I'm filing it, and I did not have a House sponsor, so I was very pleased and honored to have you file that, and I'd like you to have you come up. Thank you.
First of all, thank you, Senator Lovely, for your advocacy, your leadership, your courage, and your partnership. I truly appreciate this this opportunity to speak with you. I see a lot of young aides and interns and my colleagues. Thank you so much for my colleagues being here. As the Senator said, my name is Leigh Davis. I'm the 3rd Berkshire District Rep. I'm a new legislator, so this is a new experience for me, but I did want to introduce myself as a solo parent to three children, and also as a former educator. I taught in Ireland for 10 years to college students at the Galway Mayo Institute of Technology. And so I come from a background of a single parent, of an educator, and now as a new legislator. And it's my honor to be here. Thank you to the survivors and the advocates and so many people that are working so hard. Your testimony is, I know it takes great courage, and it's something that I'm very fortunate to speak to help you to get this over the finish line. So I do want to start off with that. I carry a deep commitment to protecting children, and wherever they live, they learn or they worship. We've heard the stories, we have seen the signs, and we know how abusers exploit power, technology, and legal gaps to cause lasting harm, often without consequence. As the Senator mentioned, just weeks after I was elected, I focused on this issue. And one of the things I did, in addition to talking to the Senator asking if I could file the House companion bill to the age of consent loophole, was I sat down with Berkshire District Attorney Tim Shugrue, who will be joining us on this in this meeting. And I said, how can I help? How can I help with this issue? And at the time, he shared his frustrations and his challenges with a deeply disturbing case in my own community, one that exposed a dangerous flaw in our laws, in the age of consent loophole. And this happened in Pittsfield in Berkshire County at Miss Hall's school, an elite all-girls school in Pittsfield, where former students came forward with allegations of grooming and sexual abuse by a teacher who worked there for more than 30 years. So this 30 years this man was in this school. They described sleepovers, they described family visits, lingering touches, a culture that blurred every boundary. And despite their bravery, no charges could be filed, because in Massachusetts, the abuse of authority isn't a crime when a student is 16 or 17. One survivor, Melissa Fares, said she was raped by this very teacher while he was visiting her family in Connecticut. Now, the issue with Connecticut is that In Connecticut, this conduct is a crime because in Connecticut, this law, their law, includes a carve-out for abuse of authority. In Massachusetts, this does not exist. We cannot let justice depend on which side of a state line a child lives. This is an issue we need to fix. And that is one of the reasons why I'm so proud to have filed H-1634, the companion bill to Senator Lovely's bill. It says clearly, no one under 18 can consent to sex with an adult in a position of authority or trust or power. Whether they're a teacher, whether they're a coach, whether they are a clergy member or a volunteer. Survivors have shown extraordinary courage in fighting for this change. Just last week, Melissa and another former student, Hillary Simon, flew in from New York and California to testify alongside me in support of these bills. They spoke not just for themselves, but for every student who's ever been silenced or ignored. But we know the problem doesn't stop with grooming or abuse of authority. It's also about hidden surveillance. It's about the trauma caused by invasive recordings and about the legal gray areas that let perpetrators walk free. In 2014, the SJC ruled that a man who took upskirt photos on the MTA hadn't broken the law because the women were clothed. How crazy is that? That ruling led to emergency legislation, but that fix left major gaps. That same year in Dalton, again in Berkshire County, where I represent, a repeat offender secretly recorded unsuspecting individuals, including numerous children, in a public restroom at Pine Grove Park in Dalton. Some charges were dropped because of the vague statutory language. And the SJC urged again for the legislature to return this law and to fix it. And just last month, as you might have heard, a student at Williams College was charged with hiding a camera in a campus gym bathroom. So that's why I filed H-1633, to strengthen our upskirting law. It closes legal loopholes. It makes it a felony to secretly record nude or partially nude children. It gives prosecutors the tools they need to hold offenders accountable. This is a zero cost, common sense, no cost fix. This is something that needs to be done because the harm doesn't end with just the recording. Survivors live in fear that those images will resurface time and time again. Too often we hear, "We believe you, but the law doesn't protect you." That's not good enough. Child sexual abuse is preventable, but prevention takes more than good intentions. It takes laws that reflect how abuse really happens through grooming, secrecy, and power. Coordination between lawmakers, educators, prosecutors, and service providers. And above all, listening to survivors and listening to those in this room and to the lawmakers that can make the change. We need to act now. H-16 and H-1633, 1634 and 1633 are about action. They close dangerous loopholes in our law and they send a clear message. Massachusetts protects children. We have the knowledge, we have the data, we have the voices in the room. Now let's give them the laws to match. I thank you again for being here. I thank Senator Lovely, my colleague. I thank all the colleagues here, and I urge you to pass this laws. It's time we act now, and thank you so much for this time.
Thank you, Representative Davis. Thank you for your strong partnership. Let's work together and we'll get this done. I want to recognize my good friend, Representative Wong, has joined us. Thank you, Rep. Wong. Next, I would like to actually have DA Tim Shugrue, who is online. DA Shugrue, looking to my staff for some help here. Is he online?
Yes.
Okay. Can someone let him in?
They said that, I think this is,
They have to send someone up?
yeah.
Okay. So while we're waiting for LIS to come up and assist us, next I would like to have come up Maria Mossaides, who is the director of the Office of the Child Advocate. The Child Advocate and I have been working on together, I think, for almost all of my terms here, and couldn't ask for a more tremendous, incredible partner in protecting children. Maria Mossaides.
Since 2013, the Office of the Child Advocate has partnered with the Children's Trust to lead the Commonwealth's sexual abuse prevention work through a statutorily required task force, which last year transitioned into an ongoing advisory council. Through this advisory council, the OCA continues to advance data-driven research, policy advocacy, and the development of resources to prevent child sexual abuse in the Commonwealth. This advisory council is made up of members from all of the state agencies that deal with children, provider and advocacy organizations, and members of the legislature who work tirelessly to build programming and policies that prevent child sexual abuse. Senator Lovely has been a major force in advancing this critical work, and I want to thank her personally and on behalf of my office and the children of the Commonwealth for the important legislation that she and her staff have filed and advocated for every session. The OCA is in strong support of legislation filed by Senator Lovely and other legislators that would ensure that professionals working with children in schools and youth-serving organizations receive training that is necessary to know the signs of child sexual abuse and understand how to prevent it in the first place. We also need standards to ensure that these trainings are of high quality and based on the most up-to-date prevention research and best practices. 2 years ago, with the legislator's support, the Office of the Child Advocate developed a free online mandated reporter training to help educators and other professionals understand when and how to report. 2 years in, over 18,000 professionals have taken the training, a number that grows every month. And we are dedicated to continuously evaluating and adding content to this much needed research. We think there is a real opportunity to do something similar with training on child sexual abuse prevention to ensure that many more professionals working with children have access to this vital information in the hope that children will be spared from the lifelong impact of child sexual abuse. Finally, the OCA fully supports legislative efforts to close the age of consent loophole. In our line of work, we know that an important part of preventing child sexual abuse is focusing on preventing the grooming of children. The law currently does not sufficiently protect adolescents from being victims of grooming by adults they trust or adults in position of authority, and this is a long overdue change. I want to thank each one of you for the time that you are spending here, for the work that you have done in the past, and the work you do continue to do today to protect the children in Massachusetts. The Office of the Child Advocate is always open to answering questions you may have on this work and to collaborate to make sure that children in this Commonwealth are safe and thrive in their communities. Thank you.
Thank you, Child Advocate Mossaides. We so appreciate your support over the years and today. I'd like to recognize that Chair Lawn has joined us. Thank you for being here. Do we have the DA Shugrue? Okay, so we have District Attorney Tim Shugrue from Berkshire County, who is joining us remotely. DA Shugrue, the floor is yours.
Can you hear me?
Yes, we can hear you.
All right, we got you now. Technical difficulties, I guess. Let me reintroduce myself. My name is Timothy J. Shugrue. I serve as the Berkshire County District Attorney. I have been a trial litigator for 39 years. I began prosecuting child abuse cases in 1986. I worked in Hamden County and Springfield at that time as an assistant DA specializing in child abuse prosecution. At that point in time, we had received a federal Justice Department grant naming us one of 6 sites across the country that began to prosecute child abuse cases. And we were sort of scrutinized about how we were going to prosecute those cases. So I became very, very deeply involved with child abuse cases since then. 32 years ago in 1993, when I was finishing up being an assistant DA and then I was in private practice, I started and operated and founded the Berkshire County Children's Advocacy Center, the first children's advocacy center in the state of Massachusetts and the first one in New England that has now been in operation for 32 years now. So first, let me just say I'm here to speak in support of both House Bill 1633 and House Bill 1634. The first bill I'll speak about is the support of House Bill 1634. The testimony I'm giving stems not just from my tenure as DA, but also as my nearly 4 decades of experience as both a prosecutor and a defense attorney, specializing in child abuse prosecution and prevention. Now, the Commonwealth has historically led the country in protection of children. However, today, over 39 states have enacted stronger legal protections for minors experiencing sexual assault, specifically minors between the ages of 16 and 18 years old. The bill we are here to discuss today already exists, believe it or not, in 80% of the states in this country, but not in Massachusetts. In Massachusetts, we have made important progress in recognizing the development needs of young people as emerging adults in criminal cases as defendants. This logic is grounded in science. We recognize that the brains of young adults are still developing and most vulnerable to manipulation, affecting their judgment, and also the easy ability to be influenced by others. Why is the same science not applied to victims of young adolescent victims between the ages of 16 and 18? It should. It just doesn't make sense. Let me be blunt. High school age youth cannot enter the consensual sex relationship with adults who are in positions of trust or positions of authority. Such called relationships are built by predators who are calculated. They use grooming techniques to manipulate their unknowing victims into believing they are consenting to authority. This is not acceptable. I must prove in Massachusetts right now lack of consent. The perpetrators of crime leave the relationship unharmed. They continue their pattern of abuse, finding new victims each year. Meanwhile, the victims carry on a lifelong pain of the trauma. Without a law to effectively protect victims, we allow this kind of exploitation. We are unknowingly legalizing sexual assault. As a law currently stands, that's what it is, legal sexual assault. This is our moment to right that wrong. House Bill 1634 gives the legislature the ability to close this sexual assault loophole, restore Massachusetts to its rightful place as the leader in child protection in this country. I urge you to pass this bill, protect our youth, send a clear message that abuse of power by people in position of trust and authority will no longer be tolerated under our laws. Today, I'd also like to address House Bill 1633, an act updating and clarifying the statute relating to upskirting. Prior to beginning, I'd like to clarify the term upskirting. Upskirting is legally referred to as electronic recording or surveillance of nude or partially nude persons. It's an act in which a perpetrator places a recording device to film people in a state of undress, often in a bathroom, shower, or private personal space. The Commonwealth's current laws are not protecting victims of this crime to the extent they should be. Even the Massachusetts Supreme Court seemed to recognize this in 2019, in the appeal of Commonwealth versus Sam Wasili, which was a Berkshire County case in Dalton, Mass. In an appeal of this case, the court stated that there were flaws in the law, only the legislators could fix them. Berkshire County recently indicted a college student, Maxwell Hall, on 16 charges related to illegal surveying individuals in a bathroom on the Williams College campus. He did this with a small camera, guised as a USB charging device. Such an item can be easily purchased for Amazon for under $25. That is just unbelievable. As technology becomes more available, so the ability of perpetrators who seek to violate people in intimate settings without their knowledge. And we're seeing it happen way too many times. I would additionally like to amend the bill to include punishments consistent with the acts of the perpetrators. The despicable nature of this crime is only a misdemeanor right now in Massachusetts when its victims are adults. If the criminal targets the children, the crime is a felony. However, the minimum sentences do not match the seriousness of the crime. They don't even match the indecent A and B under the age of 14 statute. The penalties given by people who create content by electronically surveilling unknowing individuals, they receive punishments that are far more lax than those who are caught receiving and then sharing those images of somebody else. They face felony charges, receiving much harsher penalties than those who actually took the photographs. That doesn't make any sense to me, and certainly doesn't deliver justice. On behalf of the Berkshire District Attorney's Office, I am urging the Massachusetts legislature to consider the House Bill 1633, but also to include these additions. One, to make it a felony to secretly survey or record any individual, not just children, in the states of undress or in sexually exploited positions. Number two, raise the sentence for first-time offenders, whether the victim is an adult or a minor, to a felony, and make sure we increase the penalty on children who are our most vulnerable victims. And three, to add and enhance sentencing for repeat offenders. Recognize the pattern of these harms that these individuals cause. Addressing this gap in victim protection will not only better bring justice on behalf of victims, but will also serve as a deterrent to those who commit these crimes. I want to thank you all for the opportunity to speak to you today. I'm sorry I couldn't be there in person, but that 3-hour drive is a little difficult for me. I was just there last week, so I just want to apologize for not being there in person. But I can't really say stronger just how important these two bills are. And I'm so proud that you are all here today to support this legislation and to bring these facts to light so that our public can be aware of the loopholes that we currently have. Let's be the leaders in the country again. Let's be the leaders in child abuse protection and child abuse prevention. So again, thank you for your dedication and your time today.
Thank you, DA Shugrue. We so appreciate you coming in remotely. We don't blame you for that 3-hour drive, and we so appreciate your support. Thank you so much. I also want to recognize that Leader Donato has joined us, and thank you, and Representative Moakley has joined us as well, so thank you. Next, we will have Robb, Attorney Kathryn Robb, come up, National Director of the Children's Trust Campaign at Enough Abuse. Again, worked with Attorney Robb for many years now. Actually, I remember you from law school a long time ago. She was a great advisor and teacher at law school, although I never got to take you. But Attorney Robb has made this her mission. She works not only here in Massachusetts, but all across the nation with legislatures to pass these strong laws. And she's having great success in other states, and we're hopeful that Massachusetts is going to follow this session. Attorney Robb.
Thank you, Senator Lovely, and the other lawmakers that are here today. Am I taller than you? So just some quick data, because data is important. 1 in 4 girls and 1 in 13 boys will be sexually assaulted before their 18th birthday. And that's what we know about, right? If that's not an epidemic, I don't know what the hell is, quite frankly, right? We believe that those reportings are much lower than those numbers, but that's what the research and the data tells us. The bills here in the Commonwealth, specifically Representative John Lawn's bill, and I thank you, John, 1829, and the Charitable Immunity Bill, House Bill 1830, will really help the children of Massachusetts. Right now, 30 jurisdictions have passed what we call revival legislation. Now, I'm not going to act like a law professor just now, but I'm just going to share with you that we have statute of limitations for a purpose. I am an attorney. I am an American citizen. I believe in the rule of law. I believe in due process. But statute of limitations simply is not appropriate for child sexual abuse claims, period. End of story, right? These are not slip and fall cases. These are not fender bender cases. These are not those types of cases. And I certainly didn't learn about these cases when I was taking towards my first year in law school, right? These are very unusual and they should be treated as such. Statute of limitations has its purpose. It's important for most claims. However, it is not here. And the reason is not just that these are outrageous harms to children, but that the perpetrator silences the victim. So I ask people, why should perpetrators in bad acting institutions benefit from the passage of time while victims suffer in perpetuity? Right? It doesn't make sense. It's not good public policy. And that's why 30 jurisdictions have passed revival legislation. And simply put, what that means is if you are barred by the statute of limitations, but you were sexually assaulted as a minor, we create usually a window or an age extension on that statute of limitations with revival. So on the age extension, which is what happened in 2014, I believe, right? In 2014, we extended the statute of limitations to age 53 with revival. So if you were 45 and out of the statute of limitations, you could now bring a claim. Many states, in fact, most states have passed window legislation. The vast majority are 2-year windows. And that basically creates a period of time, usually after the governor signs the bill, up to 2 years, where those innocent victims have an opportunity to now name their perpetrator without fear of slander claims or defamation, right? And they can name their claim and they can expose hidden predators and expose bad acting institutions, right? That helps our kids. Right, so we have 30 jurisdictions that have done that. We have 22 jurisdictions, 2 U.S. territories, and the federal government. The federal government passed the No Time Limits for Justice Act. It was signed by President Biden 2.5 years ago. So there's a lot of activity across the nation. And the reason we have this activity is because lawmakers are starting to understand the nature of this problem. It is an epidemic and it is affecting all of us. It's also affecting us as taxpayers. It has a tremendous burden on taxpayers. It affects our educational systems, as you'll hear. It affects our penal system, our law enforcement system, as you're also will hear. It affects our social services system. It's a burden on us as taxpayers. We need to shift that burden away from taxpayers and innocent families and innocent victims to the bad guys, period, right? That makes sense. That's good public policy. But statute of limitation reform does a couple of other things as well. It protects, and this is probably the most important thing for anyone to, to really a takeaway here is it protects children now. It's not just about a survivor from 20, 30, 40 years ago that gets justice. So it's not just about justice. What happens is when we pass revival legislation, we allow survivors to name their perpetrator and bad acting institutions. So we expose hidden predators. That's good for kids, right? That will make our children safer. It also educates the public on the epidemic that we're experiencing, and it forces institutions to do the right thing and to clean up their acts and have better policies, procedures, plans, right? Responses, training, hiring. When we force institutions to do that, our kids are safer in the future, right? So I just want to share a little bit of a personal story. This is, I'm a mother of 5 children. Very, very, very lucky to have 5 beautiful children. I am a grandmother, recent grandmother. I am. So this is my son, Jesse. I raised my children in Lexington, Massachusetts, right? Not far from here, right? So Jesse is my oldest child, and he is about 8 years old, playing Little League in Lexington, Massachusetts. So my son is now 32. I can't keep track of how old my kids are. And 2 years ago, he came into my office and he sat down on the couch in my office, and he said to me, "Mom, do you remember the time you and Dad took me to the hospital in Boston because I had this ailment?" I said, "Yeah, I remember that," right? And he said, "Well, the doctor said he took me for a test, but he didn't. The doctor took me to the basement in a dark area, and he raped me." My son was 8 years old, right? Now, I'm also going to talk about charitable immunity in a minute, but right now, my son cannot name his perpetrator because of the statute of limitations here. He cannot name the institution, the hospital, right? Also, most hospitals are charitable entities. Well, I need to show you a map because this is crazy. Okay, this is a map. United States of America. Charitable immunity has been eliminated in 76% of the states across the country. That's all the yellow there, right? And then in these red states, they've made exceptions. Some of them are caps, 250,000, 450,000. Some of them are to the level of what your insurance carrier is, right? I want to point you out to this dark spot right here. You know what that dark spot is? That is Massachusetts living in the dark ages, because our charitable immunity is $20,000. So if a jury comes back, even with a confession, and a jury comes back with a $10, $20, $30 million verdict, the judge must reduce it to $20,000. How is that justice, right? What attorney is going to take that case, right? I mean, I get it. Attorneys have to make a living, right? So in Massachusetts right now, our statute of limitations, especially regarding institutions and organizations, and our charitable immunity bill, which is archaic, absolutely archaic, needs to change. Otherwise, we will not protect our children. And you know what? I'm tired of being here. And I know a lot of other people are tired of being here too, right? It is time for this legislature to act and pass all of these bills to protect the children of the Commonwealth of Massachusetts. Thank you.
Thank you, Kathryn. Thank you. I want to recognize that Representative Manny Cruz is online. He's my colleague. We both represent Salem together. Welcome, Representative Cruz. Next, I'd like to call up Jetta, the Executive Director of Mass Kids and Enough Abuse Campaign, who will be talking about some of the prevention and education bills that we have filed. Jetta has been an amazing and strong partner all throughout for the last decade that we've been filing, more than a decade, dozen years that we've been filing these bills. Jetta.
Good morning. You know, we've heard the term epidemic, and I want to bring home exactly what that means in real terms in the lives of real children. By the way, I honor and appreciate you and our partnership. Thank you so much for your inspiration, Senator. You know, about a decade or more ago, the U.S. Department of Education issued a seminal report indicating that 1 in 10 American public school children are experiencing some kind of inappropriate sexual contact with an adult in their school sometime between K through 12th grade. We were just flabbergasted. We thought, my gosh, we have to work with schools to figure out how to solve this problem. Well, unfortunately, in 2023, just a couple of years ago, researcher Jedlick did a research study involving recently graduated high school students. And sadly, she discovered that the rate was no longer 10%, but 12%. That translates into 1 in every 8.5 students across the US. Now, some of these cases involve verbal exploitation, talking inappropriately to a child about sexual matters, visual problems where kids are sent images and photographs of individuals being inappropriately clothed or not clothed at all. And then, of course, the physical kinds of violations involving all the way from kissing, hugging to sexual intercourse. Now, you know, we keep talking about the epidemic, but I wanted this morning to take 2 minutes to describe to you here in Massachusetts what this really means. How is this playing out in villages and cities and towns across our state? So permit me to give you some real examples. We did hear from you this morning, Representative, about the case at Miss Hall School in Pittsfield. A lot of notoriety, a lot of publicity. There are a lot of other cases that appear in local newspapers that most of us never hear about, but it's our job at Enough Abuse to keep track of those cases. And so let me describe some of these to you. A Springfield STEM Middle Academy teacher was charged with sexual abuse of several middle school students. And by the way, what I'm going to talk to you about, these next cases have occurred since the beginning of 2025. We're just entering into July here. In March, a High Rock Middle School teacher in Needham was arrested for distributing sexually explicit images of minors ages 3 to 12. Only weeks later, the high school band director in Needham was arrested on similar charges. And last week, a staff person at the Needham Extended Day Program at Elliott Elementary was charged with possession and distribution of child pornography. This school system is in chaos right now. 3 of their employees in a couple of months have been charged with these heinous crimes. In South Hadley, a Frisbee coach at Pioneer Valley Performing Arts School faced charges of sexual abuse by a former student who alleges that from age 12, the coach used off-campus rendezvous to groom her and other girls into later developing sexual relationships with them. In Shelburne, the girls' ski trainer at the Mohawk Trail High School was charged in a civil suit by a former student, alleging that he began grooming her at age 13 and later sexually abused her. The athletic director at Auburn Public Schools, again, this is in the past few months, was arrested for producing and disseminating sexually explicit texts and videos to a 17-year-old student and inviting him to his school office for sex acts. If we look back a year or so, some other disturbing cases come to light. The principal at Lenox Middle High School resigned after only 2 weeks on the job when the press exposed his sexual relationship to a 15-year-old foster child in a previous job. A Chelsea High School science teacher sexually assaulted a 14-year-old student in the classroom, in his car, and in home. And when I talk about Chelsea, I have to tell you that a member of the Chelsea school committee who gave a student a ride in his car on the way home, stopped at a local parking lot, sexually abused him, taped it on his phone, and sexually assaulted him. This person is now in jail. This is a member of the school committee in Chelsea. Federal authorities arrested a Foxborough special ed teacher for sharing a video of himself having sex with a teenage student. A teacher at New Leadership Charter School in Springfield was sentenced for 8 to 10 years in prison for aggravated rape of a child and intimidation of the victim, who he had coerced never to tell. A former gym teacher at Salem Salt and Salt School is facing 37 counts of assault and battery and rape of a child, where he taught for 3 years. And then finally, and this is an amazing case, a former Peabody gym teacher is facing a class action suit filed on behalf of 50 students for sexually abusing them during his 34-year tenure in local schools. As many as 500 students ages 10 to 17 are alleged to be victims. We could go on, but you can see when we talk about an epidemic, this is what we're talking about every day in the schools across our state. Now, the common link among all these cases for me is that I believe all of them could have been prevented. And as we discussed earlier, every year since every legislative session since 2015, this set of bills to address sexual abuse has been proposed by Senator Lovely, supported by Enough Abuse. And despite broad citizen support, Beacon Hill leaders have consistently failed to act. But undeterred, here we are today again. Survivors, advocates are back in full force, attending hearings, briefings and meeting with their legislators demanding that elected officials pass the prevention package now. These bills that have been described this morning, taken as a group, could really prevent these incidents from happening in the first place. Two of the bills that I want to bring up this morning has to do with one that would require schools and youth organizations, and by the way, public and private schools and youth organizations, to train their staff about child sexual abuse prevention and to adopt a code of conduct that details specific adult behaviors that cross the line with students and must be prohibited. It would require applicants for school positions to disclose previous investigations of sexual abuse in another school or state, whether their professional license was ever revoked, or whether they themselves surrendered it in order to stop an investigation. This is happening in our state. As we heard from previous presenters, the package would close the age of consent loophole. We think that's absolutely critical. But it's interesting to note that a decade ago, when these bills were introduced, Massachusetts was at the head of the class across the US, and our bills became models for the passage of similar bills in other states. Since then, and that little sign over there, state laws, I guess it's on here, the state laws mandating child sexual abuse prevention in school. 36 states and the DC have passed these laws. 18 states have passed laws to strengthen the screening of prospective school hires for histories of sexual misconduct, or to pass a law that would prohibit the practice called passing the trash. This is helping an employee engaged in sexual misconduct to secure a job in another school in exchange for their resignation. Massachusetts is only among 11 states that have yet to criminalize sexual abuse by people in positions of authority, as was discussed earlier. And also, we are one of 11 that have not criminalized the production, dissemination, and possession of AI-generated or technologically modified sexual images of children. These bills have now been heard in public hearings, and pending action is hopefully going to happen within 60 days from the Judiciary Committee. Now, the regularity of sexual abuse incidents in schools makes it seem as if schools have the problem. Schools are the problem. And I would argue that they are not. Like moths drawn to the light, those who seek to exploit children are drawn to schools where they find unlimited opportunities to groom children and abuse them, and the legitimate cover to get away with it. School districts more and more now are demanding quality training and tested prevention policies that will stop abusers at the school door. Enough abuse is currently involved now with about a dozen school districts in 6 different counties, providing them with the training and the technical assistance that they need. I want to just take a moment to talk to you that I got up on the wrong side of the bed this morning. I found myself feeling quite angry today, angry at having to be here and having to see the survivors' faces that we have seen too often. I've been embarrassed to ask them to come to these meetings because I know how difficult it is for them, how much bravery it takes. So I was reminded of a movie. Some of you back in 1976 may not have even been alive, but there was a movie called Network, and it was about a network that was having just awful ratings, and it was causing havoc across the station. And the movie actor, Peter Finch, was on camera and he lost it. And he said, "I'm as mad as hell, and I'm not going to take this anymore." He said, "So I want you to get up. I want all of you to get up out of your chairs. I want you to get up right now and go to the window, open it, stick your head out and yell, 'I'm as mad as hell and I'm not going to take this anymore.'" What I'm suggesting today is that all of you sitting here, whether you're a legislator or a legislative aide or an intern, you get out of your chair, you go back to your legislative boss, and you describe to them how critical this problem is, that it is truly an epidemic and it must be addressed immediately. We want you to all be advocates for children. And so I want to leave you really with this sense that we've got kids that are going to be before long going back to school. Everyone's on vacation right now, but in 60 days, parents are going to be looking at how to fill their kids' backpacks with all of their their school supplies. I would argue that the legislature has to help put those new laws into that backpack so that when those kids go in September, they are truly protected for the first time. Thank you so much.
Thank you for your strong advocacy, and you're right. Let's get this done. I just want to recognize that Rep. Leigh and Rep. Schwartz are here, or were here. Thank you for being here. Next, I'd like to have Chief Wojnar come up. He's a former Dudley police chief, and the chief and I have been, he actually sought me out the first time I filed these bills over a decade ago, and wanted to share. He's been here for every briefing, comes and testifies at every hearing because of his experience as a police chief when these children come into the station with their families. Chief Wojnar.
Thank you very much, Senator. Good morning, everyone. Yes, my name is Steve Wojnar. I was a police officer in the town of Dudley for 34 years. I served as the police chief from January of '03 until January of 2023 when I retired. I was the former president of the Massachusetts Chiefs of Police Association, and I worked with many members of the legislature through over many things over the years. So I'm here to, again, address Senate Bill 1163 and House Bill 1634 about the act relative to sexual assault by adults in positions of authority. In July of 2004, I was in my second year as a police chief. And I would venture to guess that was 21 years ago, so I venture to guess even a lot of people sitting in this room either might not have been here or just were very, very young at that particular time. And so we began an investigation into an alleged sexual relationship between a 30-year-old English teacher by the name of Amber Jennings and one of her former students. It was a 16-year-old boy who attended the same school and actually had her as a teacher early in his high school career. The case not only involved inappropriate sexual acts, but also photographic material and written correspondence. The relationship had occurred for approximately 6 months. So when it came to light, we went into it, and we all believed that everything was assumed illegal in the case. And when we go to find the laws on it, they were rather vague. So we had to stick with a charge of inducing a person under 18 to have sexual intercourse and dissemination of material harmful to a minor. Now, the first charge is very, very old and archaic, and really ended up in a straight dismissal. And so the only case that stuck was the dissemination of materials case. So in September 2005, Ms. Jennings pled guilty to that charge, received 2 years probation, and surrendered her teacher's license. But she was not required to register as a sex offender. He then took the opportunity to verbally attack the victim's family through the newspaper, calling the victim's mother a lunatic and claiming that she was only in the case because she wanted money. She was completely indifferent to the fact that she was the sole cause of that case. And I just recently had run into the victim's mother again right over Memorial Day. And just as it's been brought up before by several of the other speakers, what do you have to do to go, now you go see somebody that you've been dealing with for 21 years and you still have not got something passed and something done in this case? How frustrating is that? And so I realized back then that the laws needed to be changed. I was able to attend some child protection trainings down at the National Center for Missing and Exploited Children. I served on the executive planning committee down there too. Was able to get some sample legislation from other parts of the country. As I say, 39 other states have things out there that can address these issues. I worked with then my Senator Richard Moore and Representative Paul Koyarsky. That was in 2005. We filed the first legislative act to criminalize these things. Even though nothing had passed at that time, we were told that, you know, it's important and it really has to get done, and it should get done. It shouldn't be a problem. Well, I've gone through Representatives Alicia, Senator Fatman, now Senator Durant, and then fortunately Senator Lovely picked this up as well, and she's really been a true advocate for this type of thing. And I thank her, and I also thank Ms. Jetta Bernier. I think you also see the passion and the enthusiasm she has to get these things done. And a lot of it's driven out of frustration, because I'm in the same boat. And I always note that it's important that most teachers or people in other positions who have authority over youth are hardworking, dedicated professionals who care deeply about the children that are under their care. But we've had the cases such as Pamela Smart and Mary Kay Letourneau, Deborah LaFave, and many others that have taken place over the years. And how many of you were just shocked to hear Jetta talk about the review from just January of this year? How many cases that we're talking about? And even many of those people don't qualify they wouldn't be charged with a crime, because if the victim is 16 years old, it's not a crime. So just reflect for a moment on something, because I always think of this quite often. I've had children that were teenagers. I think many of you in the room probably either have teenage children or soon to be. And so how many of you would be really comfortable with your 16-year-old son or daughter taking home their English teacher for Sunday dinner? So you got a paddle, raise the paddle if you think that's something you'd want to do. Again, so this is like a no-brainer situation that you can look at. Now think one thing too for the victims. Now, if you're that 16-year-old and this is your first love, so think about how that affected it. All of us can think about the first time we're in love, and then I got our heart broken. How does that impact our future relationships that we go forward? And how many of these people end up in positions that if they do not seek professional help or get the proper services, they're going to end up probably even committing suicide or really bothered for the rest of their life. So we're here again to try to get this loophole corrected. Okay, 20 years. 2025 marks 20 years that I've been at least pushing for this. Now, my son was not even old enough to be in kindergarten when I first started this. He's now in his mid-20s and he's a law enforcement officer himself. My daughter was 9 years old and she was in the same school district. She's now 31 years old and married. And we're still going through this over and over again. So just for the legislators to consider one thing. Police reform law was passed in 2021, an act relative to justice, equity, and accountability in law enforcement. So with that law came a provision that a law enforcement officer who has sexual intercourse with a person in custody or under their control shall be found in violation of the rape statute. Now, despite limited cases of any of those things have happened, the legislature rightfully sought to include those relationships as criminal, regardless of age or even any possible consent. So why is this law any different? Why would this be any different for that? Okay? As legislators, you're in the position to close the loophole. Okay? I'm here again, and I'll probably be back again if this doesn't pass, but I'm hoping this is the last time we have to be out here talking about these issues. I always have asked every time these things have been brought up, if you have a valid reason as to why this shouldn't happen, let's talk about it, and let's address it, whatever it might be. If there's an exception, let's include it. You never get it, but it never passes. And then you're back again listening to the same stories and re-victimizing victims and providing more victims out there for that and having other families that are out there suffering through all this stuff. So finally now, please take the time to get this done. If you have any questions or you want to discuss anything further, my door is always open. Thank you very much.
Thank you for being there from the very beginning.
Thank you.
And let's make this happen this session with you. Now I would like to invite up survivors and family. First, if I could have Laura Siracusa come up, speaking on behalf of your daughter. Thank you, Laura. Thank you for being here. Thank you for your courage and bravery.
Thank you for inviting me. Thank you, Jetta, for inviting me as well. So thank you all for listening to the testimony that I'm going to present to you today. It's not only my testimony, but it's my family's testimony. My son, who's here, he's 30 years old now, and he's a father of an 18-month-old daughter. So this is very real to him as well. But thank you again for listening to my story, and hopefully this time we can make a change. So our family has been tragically affected by the laws in place in the state of Massachusetts to protect our youth from sexual abuse within the school system. 17 years ago, our daughter, Kristen, at the age of 16, was coerced into having a sexual relationship with her high school Spanish teacher at the parochial Cardinal Spellman High School in Brockton, Mass. She was one of the youngest in her junior class, having a birthday in August. Friends and family would describe her as talented, fun-loving, active in sports, and an excellent student. In fact, she was accepted and went to Providence College for one semester. However, even though she had all that going on for her, she was also vulnerable, impressionable, and struggled with self-confidence in her teen years. In hindsight, she was the perfect target for a predator that was charismatic, worldly, and complimentary to her. In less than a year, this teacher, 33 years her senior, methodically earned her trust and admiration. Grooming began with statements like, "You are the daughter I never had." Once that trust was formed, he was able to convince her to have a physical relationship with him, lie for him, and leave her family, which included her only brother, Anthony, grandparents, aunts, uncles, and her close friends that she grew up with. Every single close friend she grew up with, she turned her back on. In the end, we became the villains in our daughter's eyes once we learned the extent of their relationship. So in 2010, we hired an attorney and presented our case to Cardinal Spellman High School. The school did an investigation, as they should, interviewing myself, my husband, our daughter, the teacher, his wife, and his family. He and his wife and our daughter were able to convince the superintendent and president, that we were not fit parents and that their relationship was not of a sexual nature, After the investigation, the school determined that there was not enough evidence to terminate this teacher. If you can only imagine getting that call that he's being reinstated back into the school system and that they were bringing him back into being able to be a predator to others. After the investigation, the school determined there was not enough evidence to terminate this teacher, and he was allowed to return to school. It was apparent that this teacher's coworkers knew of his inappropriate behavior because we received thumbs up from several of the teachers when we were leaving the school after making our presentation. Shortly thereafter, after feeling like we had nothing left to believe in, shortly thereafter, when he was reinstated back into the school, by the grace of God, we came across a Sims card that our daughter had tucked away in an old pocketbook she left behind prior to leaving us. On the Sims card were sexually explicit photos of the teacher in a hotel room with our daughter. He was only terminated after providing Spellman with these graphic photos of their sexual relationship. We were told by the school that he would never teach in the state of Massachusetts or in a Catholic school after the Archdiocese was notified. We have no confirmation that he did not go back to teaching or where he ended up working after his termination. However, he has been incredibly involved, as is his wife, in youth organizations within the Weymouth community. As a next step, we notified additional legal counsel, our local police department, and the Weymouth Police Department, to surprisingly find out that we were not able to take any legal action against this teacher due to the current laws that are still in existence now 15 years later. This predator physically and mentally stole our daughter from us. There are many examples of how a predator can take control over a teenager's decision-making. One heartbreaking example is our daughter not visiting her beloved grandfather on his dying bed only a few months after, after leaving the family. Her friends and family reached out to say they would attend the wake and funeral with her to support her, but she did not show up. This was her papa that she loved so much. prior to meeting this teacher. She was incredibly close to her papa and Nana, and he stole those moments from her, from them. He stole those moments from them. Her brother, at the age of 14, kept looking for her at the Bourne Cemetery, waiting for her to show up. She never did. Not even a sympathy card to her grandmother. This is a horrible example of how someone at that age can be brainwashed by someone so evil in such a short amount of time. It's unfathomable to me and my husband that a 16-year-old is legally capable of giving consent to a 49-year-old teacher to have a sexual relationship with her, and her parents have absolutely no legal recourse. At age 16, she was not able to buy cigarettes, alcohol, vote, barely able to drive a car without another adult in the car with her. How can she consent to having a sexual relationship with a 49-year-old teacher? This teacher knew the laws in the state of Massachusetts. He was able to have sex with her at age 16 and convince her to leave her family when she turned 18. We cannot continue to allow these individuals, whom we should be able to trust with our children and that are in a position of authority, to engage in sexual relationships with them and give them the legal right to use that consent as a defense. Since 2012, I have been a member of the board of directors of Enough Abuse. And honestly, that's been a savior to me. And thank you, Jetta. To help change these laws, over the years, I've testified twice at the State House and been interviewed by the Boston Globe, and continue to be an advocate for change in Massachusetts laws to protect our children. The number of children being coerced into sexual relationships with individuals in positions of power continues to grow. We see it on TV, read about it in the papers and online daily, as Jetta has stated the most recent cases. How many more teenagers need to be traumatized before turning our back on them? I respectfully ask that in 2025, this year, please, each of you take a stand to protect our children. Enough Abuse, formerly Mass Kids, has developed remarkable preventable tools for school administration, and they are at the forefront of changing the laws to protect our youth. Passing the prevention package bills will provide a safe environment for our youth so that no other family must deal with the loss that our family has endured. Thank you for listening to our testimony, and I hope that you can help push these laws through this year.
Thank you, Laura, for sharing your personal, very personal, and painful journey. And we promise we are working so hard to make that change. Thank you very much for being here today.
Thank you for fighting.
And now I'd like to call up Lori Ledger to speak on behalf of your niece and introduce her.
Yep.
Thank you. Thank you for being here.
Hello, thank you. In Franklin County, next to Berkshire County, the same thing is going on. A trusted 50-year-old coach, husband, father of 2 girls, groomed and sexually abused my niece. She is very courageous. She spent the past 4 months in inpatient trauma therapy. He is free to do it again. He is driving around town. He knows he got away with it. There's nothing we can do about it. Had you passed these laws, we wouldn't be here today. And Erin wouldn't have had to spend 4 months of her life in trauma therapy. She, like I said, is an extremely strong woman. And she is here today to talk about her abuse. Do you want to come up?
Yes, exactly. Read it off your phone. It's okay, take a deep breath.
Hi, everyone. Apologize about my voice. My name is Erin Laffond, and this is only just a glimpse of my story. My experiences as a child were quite different than those I grew up with. I was adopted and accepted into a home here in the US before I was the age of 1. And my adoptive parents in the community of Row, Massachusetts, they became my family that grew into love and many friendships. What I admired most about my family is that I grew to trust and confide in the people around me. The community, the flow of support and safety into my life was unwavering. As I got older, though, the nuances of being adopted became more pronounced. I didn't look like the other teenage girls around me. My skin was different, my hair was different. I didn't look like my adoptive parents. When they came to pick me up from sports games, the way that I was looked at by other parents was really confusing to me. The way my academic success was commented on in surprise was really discouraging. And from a very young age, I became aware of the fact that because of my race and ethnicity, I was going to have negative interactions with the world more times than I deserved. And when you're a child, this is a terrifying reality to learn, especially because you won't understand the complexities and complications of it. And on top of any teenager being sensitive, vulnerable, and overwhelmed and navigating the perpetual constraint of cultural expectations of youth, this heavy sheet latched to my identity impeded my vision. How do I fit in? Will people accept me, and who am I supposed to be? And when young people ask these questions, or they're exploring how they identify in the world, or are trying to navigate social acceptance, they're to be met with the utmost patience, validation, mentorship, guidance, and protection. My resources of adults I could trust when I was 16, it was abundant, and I communicated my needs in the ways I knew how. I believed any adult in my life at that time, if asked a question, they would give me nothing but their honest truth, and their words would keep me safe if I expressed my curiosity and insecurities. I was met with affirmation and love much of the time, which I want to recognize as a privilege some young girls and youth just do not have. What is most horrifying, though, about my experiences at this age is that my attempts to seek structure and belonging and the guidance that I desired so much to have turned to deceit and coercion. And between the ages of 14 and 17, I was groomed and sexually abused by a man who not only was a father-like figure, he knew me when I was a baby and I came over to the US. He was also my employer for 5 years when I started at the age of 14. And he was my high school ski coach for 6 years. So there was really, no way I ever could go a day without seeing him through the ages of 14 to 19. And he emotionally and psychologically manipulated me by using these positions in superiority as a recognized community member to disguise his actions. And he took advantage of the power that his roles gave him, using his reputation as leverage to keep me quiet. And me, a 14 to 17-year-old who desperately wanted to people please everyone and anyone just so people wouldn't look me up and down with questions. Or feel a need to justify my presence in my community. He knew this was all I desired, and he knew I was angry and hateful towards myself for feeling isolated. If he asked enough questions that could be recognized as genuine or appropriate, there was a change in his tone when he would find a window to cross the boundaries of comfort. He gave me compliments like I was easy on the eyes, or if I were in high school during my younger years, I would have been trying to date you. But the fact is, it didn't have to be in that time period because he essentially was trying to date me. That's what it felt like. He gave me, sorry, it never ended. This was the beginning. This was his way of giving me the validation I was looking for from my peers, from my family, from my education, but only if I gave him my body and my vulnerability to contort into whatever he wanted. He'd ask me to fulfill his fantasies, wear clothes that would accentuate my chest or my stomach. His words were never genuine, and he knew that. The ulterior motive of his guidance was either sex or touching my body in whatever way felt pleasurable to him. And I became so lost in what was okay and what wasn't. In a time in my psychological and biological development, my exploration was not my own, and I could not grow boundaries because they were being puppeteered by someone else. And remember, adults at this age are the people you are supposed to trust the most. When you told me to get more toned on my stomach or have slender yet muscular legs, I was a gymnast for a very long time. I had an injury when I was 16, and that really spiraled into a lot of different mental health issues for me. So I'm in this susceptible state, and I wanted to be perfect for anyone. So I was going to do my best to follow through with this task. He told me I'd be attractive, and in my head that meant people might acknowledge me. Give the people what they want. An attractive, toned, tan woman. But I wasn't a woman then. I was a child. Imagine constantly being told that the damage you would cause someone and their family if you spoke even a word about any of this. Imagine the exclusion and isolation I was afraid of. If I was the one who ruined a community member's reputation such as his, it would be all my fault, and I would hate myself for the rest of my life. But the irony of this was that I never had to say or do anything with him to hate myself. The levels of shame and disgust I internalized just carved an even deeper crater in my heart, an identity that is so deep and painful. No young person should ever have to feel their voices silenced by any adult. To feel that the institutions that promise and promote safety, creativity, growth, and inclusion will in fact follow through with their words and protection. Not to forget about the adults who are protected by their status, who use their authority in any form, and youth within the communities. Youth deserve to discover their core values and beliefs about themselves with agency and self-identity and self-exploration. It is not anyone else's choice to make but theirs. I mean, please, hearing these stories and this data, please make the right choice in passing these bills to provide the care and protection for it truly belongs to. Their mental health is so important. And today I work with a youth development organization in Connecticut. And those students My God, I love them so much because their stories resonate with me and are so deeply connected in ways they don't even know. But I get to stand with them every day at my job, and I get to advocate with them, not for them. Because they deserve to have a voice. The voice of people who hurt them is not the voice that we should be hearing. And right now, that is what is happening. So please, this is not something I would ever want any child or adult to go through. And I did. I was very fortunate to get treatment. And I know many youth do not have that. And that breaks my heart. But I'm so happy that I had a clinical team that got me here today and continues to get me through every day. And I have family that stands behind me. And I have people that stand behind me. Because it's not isolating. I want it to feel empowering. So please help me feel empowered.
Thank you, Erin. Thank you for your bravery to come in today and share your story. Because you're a survivor. I don't refer to when we were victimized, whatever that, refer as survivors. You're a survivor. So thank you so very, very much. That concludes our briefing. We do hope that for those of you who are here on behalf of your legislators, please go back and tell them how important this is. We are available to talk to them. For the legislators who have been here, thank you for your support. To the panel, everyone who's here, we stand with locked arms to get this work done. We have a couple minutes for any Q&A if anyone has any questions, but we thank you so very much for being here today.